BTC's on-chain fingerprint. Implications on recovery strategy. In Smithers and another versus persons unknown Category 1 and others, the English Commercial Court granted summary judgment in favour of two victims of a crypto-asset fraud, ordering the return of Bitcoin and awarding compensatory damages for fungible tokens. The decision, handed down by Mr. Justice Bright, offers an insight into the practical realities of crypto-asset recovery. Background. The two claimants, Ms Nancy Smithers, a Canadian national, and Ms Angelina Usanova, a Maltese national, were induced to invest the equivalent of approximately £10.5 million with what they believed to be a genuine crypto-asset trading platform operating under the name Raliplen, and later Servelius. In May 2025, Ms Smithers was contacted by a man who claimed to be an expert trader and persuaded her to open an account and transfer both fiat currency and crypto assets over a period of months to Servelius for trading. Ms Smithers introduced Ms Usanova to the fraudster, and Ms Usanova likewise transferred crypto assets to Servelius. By October 2025, the fraudsters, known only by aliases, had removed all the crypto assets from the accounts and disappeared. Tracing and service on the blockchain. Specialist investigators were able to trace the stolen assets to exchange deposit addresses and final destination private addresses. In some cases, the individuals behind those addresses could be identified. In most, they could not. The claimants brought proceedings against persons unknown and effected service by transferring either a non-fungible token containing a link to the proceedings or an OP_return message directly to the relevant receiving addresses. Our previous article, Jurisdictional Issues in Cryptocurrency Disputes, Part 2, Service on Persons Unknown and Service by Alternative Means, identified authorities, including Deloyer and Osborne, which recognised NFT airdrop as a legitimate mode of service. Smithers confirms that this technique is now firmly embedded in mainstream commercial court practice and not merely a novel workaround. Bitcoin, a discrete and identifiable unit. The court accepted expert evidence that Bitcoin transaction outputs do not commingle into a single homogeneous balance. Each unspent output remains discrete and uniquely identifiable until it is spent. In this sense, Bitcoin differs from many other types of commonly traded cryptocurrencies which are fungible. The fact that the Bitcoin that was misappropriated by way of the fraud could be identified as the very same property in the receiving wallets meant that the victims were able to follow their proprietary interest into that particular property, and it was ultimately ordered to be returned in specie. By contrast, the court found that USD Coin and Ethereum, being fungible, had lost their identity upon transfer to and receipt by the receiving addresses, such that it was not possible to identify precisely the same assets as were taken from the claimants. The claimants therefore elected a compensatory remedy in fiat for those tokens, rather than pursuing a proprietary restitutionary claim. This distinction is instructional for practitioners structuring proprietary injunctions and tracing claims, and echoes the tracing and constructive trust principles discussed in the first article in Harneys' cryptocurrency publication series. Jurisdictional Issues in Cryptocurrency Disputes, Part 1. Service out of the jurisdiction. Judgment despite silence. With no defendants appearing, the court proceeded on the R.V. Jones line of authority and granted summary judgment for deceit against the receiving defendants, together with indemnity costs of £230,000. Comment. The underlying asset tracing exercise in Smithers, which identified exchange deposit addresses and the individuals who ultimately controlled them, is a good example of the investigative groundwork that will often need to be undertaken before pursuing legal action, such as Norwich Pharmacal and Bankers Trust applications against exchanges in the Cayman Islands and BVI. As explained in our article, Identifying Wrongdoers in the Crypto Space, the Norwich Pharmacal and Bankers Trust jurisdictions. The judgment also highlights several important points for practitioners. First, the importance of distinguishing between Bitcoin and fungible tokens when determining the available remedies. The court ordered restitution in specie of the former and compensation in fiat for the latter, which demonstrates that, when it comes to crypto fraud, the courts will look beyond the umbrella term cryptocurrency to engage with the technical architecture of individual tokens when determining what remedies might be available. Bitcoin's transaction model, which preserves each unspent output as a discrete unit, made it possible in Smithers to follow the very same assets into the receiving wallets. As the Bitcoin remained identifiable as the claimant's property, the court ordered that it be returned to them in specie. By contrast, the USDC and Ethereum, being fungible, had lost their identity upon transfer to the receiving addresses, and it was not possible to identify precisely the same assets as had been taken. The claimants therefore elected a compensatory remedy, expressed in fiat currency, for those tokens. However, the fact that a proprietary right cannot be followed where a fungible token has been misappropriated and subsequently commingled with other assets of the same type does not necessarily preclude proprietary relief. A claimant may still be able to trace into substitute assets acquired with the proceeds, or assert a constructive trust over identifiable funds, applying established principles of equitable tracing. The judgment in Smithers did not address those tracing concepts because the claimants were unable to identify the specific proceeds of the misappropriated assets and elected to pursue compensatory relief against the wrongdoer, in personam, instead. But it is important to bear in mind that fungibility alone will not defeat a proprietary claim. The question remains an evidential one about whether the asset, or its traceable proceeds, can be identified. Second, the use of NFTs and OPRETURN messages as a means of service on unknown defendants is now part of a growing body of changes seen to recognized methods of service. With Cayman and BVI courts already recognizing NFT airdrop and alternative service as consistent with their own procedural rules, and taking a consistent approach to the situs of cryptoassets for jurisdictional gateways, Smithers is a template English decision that offshore practitioners can expect offshore courts to follow closely in jurisdictions such as the BVI and the Cayman Islands. Third, the judgment underscores the practical reality that investors remain vulnerable to sophisticated crypto frauds, which are more prevalent than ever and often the product of large scam centers. That the claimants ultimately succeeded in this case owes much to the quality of the initial blockchain analysis and the procedural creativity of their legal team. Responding rapidly to wrongdoing, tracing the movement of stolen assets, and ensuring that any claim can result in the practical return of assets from day one is essential. Harneys does not advise on the law of England and Wales.